Take it to trial. Take it to trial. Welcome in, grab a seat, hit the like and subscribe. The sweet peas on the mic with that spicy little vibe. Got the courtroom streaming in the chat, going wild. We're debating heavy topics, but still laughing like a child. From objections to confessions to the judge's side eye. If it's justice and it's messy, we gon' talk about why. Every day's a new case, every moment's a ride. And when sweet peas in the building, we be learning with pride. My eyes on deck, keep the room running smooth. Film freak therapist, you know, keeping everyone in the groove. Right to with the facts, pretty brown girl with the sass. Moreldia and Fowler keep the peace in the chat. But Jason walks in and the ladies collapse. Chocolate, take it to trial, where the truth gets loud and the laughs run wild. Sweet peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. Morning shows are sharp, afternoon is on fire. And we catch every moment that the court might inspire. From witnesses whispering, the lawyers trying to hard. You know Sweet Pea breaks it down like a legal tarot card. Chats cracking jokes, dropping theories on the fly. We're serious when it counts, but we still testify. Minds hold it down when the trolls try to play. If you're out of line, court adjourned for the day. But when Jason logs in with that deep hello sound, the ladies in the chat, man, they all fall down. Take it, 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 take it to trial, where the truth gets loud and the laughs run wild. Sweet peas got the spice, she's the queen of the aisle. Chat fam rolling deep, we've been here a while. Lights on, mics up, we gon' do this right. Take it to trial, every day, every night. Take it to trial. When the sun goes down and the cases get deep, after dark gets spicy, no secrets to keep. Taboo topics, big laugh, slap, happy crew. Sweet Pea says behave, but we never really do. It's opinions, confessions, stories untold, but we handle it with heart like the chat made of gold. Hey! Take it to trial, from day to night and every wild mile. Sweet Pea's nearly strong with her trademark style, and the fam in the chat always makes it worthwhile. Turn it up, show some love, hit the like on sight. Take it to trial, yeah, we live tonight. Take it to trial, yeah, we live tonight. Take it to trial.
I don't even know which
Take it
one.
to trial.
I do not get it twice. We are not doing it. We can't do it twice. I'm over here trying to figure out how to I'm trying to get this thing together. You know what? I came with you. I'm just looking at your comment. Good morning, Allison. First in the building. Hey, Marilda. Good morning. Good morning. Good morning. Hey, SD. I see you. You woke up. You on time for court. Hey, Drunky. Good morning. Hey, Christine. Good morning, honey. Hey, Film. Oh, Hey, Drunky. Hey, Tanya. I'm going down there. Hey, Northwest. She said, but she do need a new trial. She said, y'all were wrong. Thank you so much, Christine. Hey, Dandy. Hey, only. Only. Yeah, he'll get a chance to hear it at some point in time, SD. I guess he'll hang out with us for the day. Maybe not. What you mean you gotta leave in an hour? We just got here. You're always starting some stuff. Hey, Beezy, good morning. Is this the one I'm gonna be sharing? Let me see. Okay, yeah, I think that's it. That look like it's it. I don't know what the hell. I don't know what Daisy talking about, and I don't know why she even talking about it. But whatever, we gonna see. I was asking. Yes, I was asking yesterday because if you know anything of, well, let's put it this way. If you know anything really about like my case watching, or how I got started with watching cases, it was more or less let me pull this out just so we can be set up together. Okay. I didn't have to order this, but so they got it on the website. So yeah, so that's what I had to ask yesterday, because I'm like, everybody asks for a new case. Like, what is that about? Everybody asks for a new case, a new trial. Like, no matter, I mean, what? And okay, so only fair, you putting the answer in there. Is there right to try? But I mean, okay, I guess. I was just like, okay, I was like, everybody doing this, and I didn't understand why. I couldn't put two and two together. But I'm glad that we got through that. I'm just gonna just talk about this real quickly this morning. That way we can go on back in the courtroom with Rusty. Dang. Anytime that I think about somebody named Rusty, I want to put Dusty on it, but not this Rusty. Not this Rusty in this trial that we watching. I wish you would. We gonna put Rusty and Stallion. So we gonna read parts of this motion for us to have, and I'll just give a brief overview in regards to Daisy. For those that, if you didn't watch the trial, we did cover that trial, so it is on the website, on the channel from day one all the way through. For those that have not seen it, she is accused. Well, she's convicted. I guess I can say convicted now, because she was convicted of first degree murder. Redrum. I better say redrum. First degree redrum. And her boyfriend's unaliving. She's also the one that was real famous because of the fact that she had told him, after she had pew-pewed him, she was like, "You'll be all right, homie. It ain't nothing but a little bit of blood." And she kind of like walked away, and they caught it on camera, her saying that. And she's the only person that was in prison that we know of that has had conception, then made a baby. Her and somebody else in the prison cell, they didn't went half on the baby. So she got pregnant while she was in jail through the vent. So we got a vent baby. So we got a couple different dynamics with this. This is in Florida. Of course, like I said, she got convicted of first degree redrum, and he was the father of her child. So, yeah. So I guess now she was convicted. I want to say it wasn't that long ago. But we gonna look at some of these key points in their motion, their briefing that they have for their response. Okay, so this is the state's response to the defendant's motion for a new trial. So this is the state responding because she asked for a new trial. Wait a minute, maybe I got up the wrong document. Let me see if I can find her motion, because I need her motion to see what was she claiming. Oh, here we go. I don't know. I don't think they're gonna win this. I don't think they're gonna win this at all. Y'all, if y'all can see right here, the state Their response is 33 pages from what I can see. Ooh, that's a lot of pages. But right here is the defendant's motion. I believe this is going to be the defendant's motion. It says defendant supplemental memorandum in support of a motion for a new trial and or a motion for a new judgment of acquittal. Her request is only 4 pages long. Yikes. So that means whatever she is trying to say in her 4-page letter, the state was like, well, no. We'll write a 35-page. We're going to write a 33-page letter telling you all the reasons why this will not happen. Okay, so let's get started. Do I got the right page up? Nope, I surely don't. And then we can get over there into our Melody Ferris wheel case. And for those that were not here to vote yesterday, it looks like we have voted on the Mew case is going to be the first one that we do. Am I correct in that? The Applegate River case? Okay, so here we go. State's response. Oh, that's the same one. I don't like how they have this red thing on here, which is fine. I mean, I can read past the red stuff. I guess my only problem is that it's confusing me with the document. Defendants. Okay, that's the defendants. I think I just got multiple versions of it up at this point in time. Okay, let me get this up. Let me get this started, rather. I must need to probably close them all down and try to pull them all back up. I got too many things going on up in this screen. That's what it looked like. Okay, here we go. Yeah, okay. I wanted to make sure my mouse was on there. Let me see if I can make this bigger. I don't want a thumbnail. Full screen. Oh, no, I can't do full screen. Y'all know me. I'm just trying to figure out what's the best way of showing y'all so y'all can see too. Oh, okay. That look like that's a good way. It look like y'all can see most of it, right? Okay, so it says defendant supplemental memorandums in support of a motion for a new trial and or a motion of judgment of acquittal. What? This was filed on November the 21st, 2025. Nope, SD. I'm just seeing your thing. Nope, actually it wasn't. Hey, Fortnite. Yeah, Vent Baby. We got a Vent Baby imp in this one. No, I got this at Walmart. It was $5. I was like, you know what I'm gonna do? After after the holiday, I'm gonna go over there and buy up all the stuff that wouldn't nobody buy. I'm gonna start doing that because it don't make no good sense. $5 for it. And the headband look like something I could have made at home. Hey, the Curville. Hey, Curville, how you doing? Okay, let me get started. We ain't gonna never get started with this. It says defendant Daisy Link. by through and through her undersigned counsel in pursuit of Florida, all these doggone codes, moves this honorable court for entry of a judgment of acquittal. What? In lieu of a jury verdict, or alternately, an order setting aside a jury verdict in the case and granting a new jury trial. Is she asking for a whole acquittal after the jury has convicted her? Oh, really, Dandy? I have to go in there. It's been a while since I've been in the Hobby Lobby. You go in Hobby Lobby and you might lose your whole life up in there. I was like, they got way too much stuff in there. I can't. There's too many colors, too many sections. Oh gosh, yeah. It's like you need to take a day out, and that need to be a field trip. So it says, in support of the foregoing, the defendant will supplement her previous file motion with the following. So the defendant link asserts that the arguments made by the state during their closing argument amounted to plain error and warrants a reversal. Defendant realleges and maintains the other points raised in the motion for a new trial, but files this memorandum to expand solely on the issue of improper arguments and comments made by the state during closing. So they think something that the state has said during closing was improper. In the instant case, the state presented photographs during the closing and used those photographs to argue that it would have been impossible for Mr. Jimenez to reach in through a window from the outside of Mrs. Link's home and unlock the door to the home. It is clear that that argument was prejudicial, because the jury immediately within 5 minutes of beginning their deliberations asked a question on this very topic. I remember the jury had a question. There is no question that this argument, coupled with the manner of the photographs were presented during their closing argument, it was false. It was very misleading. Counsel for the state, of course, they apologized for this once they learned that there were photographs and evidence, one in particular, which fully negated this argument and proved that Mr. Hernandez easily could have opened the door to the home from the outside. So they stand, because I guess one of their biggest gripes is, and I remember the jury coming in and asking a question in regards to if he was able to get in that door, unlock that door through that window. So, and they asked a question about that, and it seemed like what they're saying. But if closing statements are not arguments, I don't understand why this would even matter. Because closing statements and open statements is not arguments, it's the actual evidence. Wow. So it says, however, this was not done until 45 to 60 minutes after the jury submitted their question. The jury returned a guilty verdict shortly after the photos were presented. I do remember that, if y'all don't remember it. So that happened very quickly afterwards, too. So they saying for these reasons that she should have a new trial. Let me see what other reasons. Do y'all think that's a good reason for her to have a new trial? Because I think this is going to go back to where I see some stuff. Remember, because they had a stand your ground hearing. Because that's what she was trying to say, that they were doing a stand your ground for her. Let me see. I'm trying to see if I can see if they have the... Okay. Okay, so that's one of the issues that they have. Let me show y'all the other issues that they also. Let me pull up the other document for us to look at. Remove. Stop. Drop. Shut them down. Open up shop. Oh no. Let me see. I don't know. She got too many dang on documents. How about that? I just found this other document on here that I'm gonna share with y'all. Hmm. That is going to be this one. Okay. There we go. I'm going to close these down as I'm reading them because they are going to have me in a hot, confused mess this morning. I have not had enough coffee for this at all. No, no, no. Okay, so this is the first part of her motion. It was filed on 10/23/2025. So I'm assuming that this was shortly after she was convicted. So just the same thing, stating who she is. The trial began on October the 8th, 2025. It's saying the evidence portion of this jury trial lasted 6 days with closing arguments that occurred on October the 16th. Gosh, the jury only deliberated for approximately 1 hour and 45 minutes. God, that was a very quick verdict. Okay, let's talk about the two children that they have in common. Pedro attacked and seriously injured Daisy 5 days prior to the alleged redrum. Daisy and PJ, one of her children, both testified that another individual named David Perez was present and witnessed the attack. Also present were PJ, MJ, and 4 other children, I guess during this attack that they had. They saying Pedro, in a jealous rage, proceeded to attack Daisy, discharged a firearm in her direction, and pistol whipped her about her head. Remember, we saw those photos. And this was in the presence of not only of his 2 children, 5 and 7, but in the presence of 4 other children and in the presence of David Perez. Do y'all recall, was David Perez, did he testify? I don't recall seeing a David Perez testify. Do y'all recall seeing a David Perez testify? Okay, Curville said if it wasn't for PJ, she probably wouldn't be alive. Okay. But do y'all recall, did David testify? I don't remember nobody named David testify. So they stand per testimony of Daisy, Crystal, Josephina, Leanne. Daisy was planning to move to Texas with PJ and MJ. This was planned, what was without known to Pedro. Didn't she walk out of the hospital, or am I thinking of another case? No, this one, she I don't know, he had whooped her butt really good like 5 days before, and something happened where he came back to her house uninvited, and an altercation must have happened, and she ended up, I think she pew-pewed him, and it hit him in his foot, in the back of his foot, and the bullet traveled and hit an artery. You think David did testify, OnlyFans? So it was kind of like the bullet went through his foot and it traveled and ended up hitting a major artery like in his thigh area, and he ended up like bleeding out. So you say David may have testified. See, I don't remember if David, I don't recall a David, but that doesn't mean that a David didn't. So it says Pedro had an address with his parents listed on the driver's license. Pictures of the driver's license issued to Pedro were both found at the scene. Yes, heel. Okay, yeah, I thought it was somewhere like his foot or somewhere. Yeah, yeah, Dandy, that's it. I mean, it's the weirdest thing that, like, kind of like, I think I seen somebody put in there earlier in the chat, like it was just like really a freak accident, like how he passed away. Like crazy work. So it says both Daisy and Josephina testified that in the hours prior to the homicide, Pedro physically attacked Daisy on at least 3 occasions while on her property. Pedro was asked to leave about 5 different times. Pedro would not depart the location. But see, the problem was with the testimony from the sister, the mama, they had a lot of issues with the mama was out there watching court TV, like they were doing a lot of stuff. And guys, this is where the ME was like, look, our guy Pedro, he had healthy amount of cocaine, Coca-Cola, whatever you want to call it, in his system. Like the Coca-Cola amount that he had in his system is probably what kept him alive as long as he was alive. So the medical examiner, through his testimony, said that Pedro was up under the influence of Coca-Cola, alcohol, and what we call medicated at the time of his unaliving. The ME sarcastically classified the amount of Coca-Cola that he had. Oh, yeah. Pedro, they got it in their thing as healthy. I was like, oh my goodness, I can't believe there's a healthy amount of Coca-Cola you can have in your system, but apparently you can. During his testimony, meaning it was significantly a large amount of Coca-Cola. Coca-Cola. I probably shouldn't say Coca-Cola. Coco? Because I don't want Coca-Cola to be mad at me. Coco. I don't know. Maybe Coco. Will you call it Coco? I don't know. I have to find out something to call it. He had a blood alcohol level that was above the legal limit for driving in Florida. So he was like Coquina. Okay, I gotta put these little magical words up here because I'm not gonna remember. I'm gonna get some sticky notes and put them on my computer because I need to remember coquina. I need to remember uh uh some people call it red rum, some people call it redrum, some people call it unalive, I don't know. I just don't understand why we can't use regular dictionary words. I don't know. Booger sugar? Oh goodness, not booger sugar. You would come up with that, SD. Damn gone booger sugar. The medical examiner also verified that there was one bullet fire which caused the 2 entry wounds and 2 exit wounds. The initial entry wound was on Pedro's heel. This is generally consistent with a gun being fired in the downward trajectory. I can believe that, towards either the ground or either towards Pedro's feet. Right? Oh, so maybe I should do a poll because do we think that the jury got this right? I don't know if the jury got this right. Let me put us a poll up here. Because I don't know. I don't know how I feel about that. I don't know if the jury got this right or not. Or did they not get the right evidence in to make sure that they didn't get this conviction that she was convicted of? Hold on. Okay, and we have that she was actually convicted of um gosh, she was committed I mean, she was guilty of first degree. Gosh, okay. I don't know. Let me see what y'all think. I wonder, did they have multiple options? Maybe we can see if we can find a jury form. I can't remember. Did they have multiple options in this and with this one? Mm. Okay, so most importantly, the testimony is corroborated by the videos introduced at trial, which depict Pedro running around outside Daisy's home, where Daisy can be heard yelling at him, telling him to leave. Oh my goodness. Wandering around outside Daisy's home shortly after 3 a.m., where he can be heard screaming, "Do it! I'm ready to die." Seconds after Pedro is heard screaming, a single gunshot is heard. This gunshot is heard before Pedro is seen running away from the premises in the direction of the alley where his body was ultimately found. Wow. So right here, they're talking about during Daisy's testimony. Daisy stated that Pedro snuck up on her outside by the home, grabbed her by a hair, causing her wounds from the 5 days prior to reopen, and he threw her to the ground. Daisy then grabbed her gun and pointed it at Pedro, demanding that he leave. Pedro refused to leave and advised that he would lock her out of the home and barricade himself inside the home with the two children. MJ and PJ were sleeping. Pedro then started scream the following words to her: "Do it. I want to die," and then proceeded to run towards the home and break in and barricade himself. While he was running towards the home, Daisy fired one shot towards the ground in hopes that it would scare him off. And after the gunshot, Pedro ran away towards the alley. This is corroborated by the video evidence, which shows that Pedro is running away and towards the alley. Gosh, this story sounds very plausible. What do y'all think? No, Drunky, she only shot once. Tyan said, no, the jury got this crap right. She shot at him on purpose and boom. But I'm saying when you go off of what she's saying happened, if we do got video evidence to see some of this stuff, right? And so I guess my question would be is like when we using the stand your ground rule, like she had no reason to retreat from her home. So this is just more about the home and those things. So what happened right there? Let me see what else I got. Okay, let's just talk about statements. Of course, because I'm not reading all 15 of these pages. That is just not going to happen. So I do see here they're saying it's painfully obvious that the jury either misunderstood or misapplied the law on justifiable use or deadly force. The jury foreman in this case gave multiple interviews. There we go. Somebody then talked. Here we go. The jury foreman in this case gave multiple interviews to the media, and those interviews are available in a public domain. In those interviews, he stated that it can be self-defense if someone is running away. This statement from the jury foreman indicates that the jury either misapplied or failed to even consider the instruction on justifiable use of deadly force to prevent the commission of a burglary and or false imprisonment. Furthermore, the jury's apparent conclusion that Pedro was running away when he got shot is not supported by the weight of the evidence. He wasn't running away. He was in the process of committing a forcible felony. Pedro only ran away after Daisy fired the weapon. And this is corroborated by the video and the evidence in the case. So they saying that the jury got it wrong. You want to find the foreman's interview? Let me see. I don't know. I have to see if I can find it. Let me see if I can find a video. So the juror that spoke, his name was Keenan Bowie. I don't know. I got some sources saying that it was she was convicted of second degree. Oh, SD, I meant to tell you, I seen that case for that lip filler. They doing the what is that called? They doing the closing statements. Like, how are they doing the closing statements for that? And they didn't even show the trial. That is like so super weird to me. I'm trying to see if I can find the interview. Let me see if they got a little clip up here. Yeah, I don't know. Now I have to see if I can find it. Maybe I can get it sent to me. Okay, let me see what else is on here. Okay, of additional concerns with the jury is that this case had a great deal of publicity long after the shooting, right? Yeah, we remember that. They were watching it up in the courtroom. For these reasons above is supporting the evidence. I don't know if that's enough for a retrial, though. I don't know if that's enough. Okay, let me take that out. I don't know if that's enough for that. But then again, I don't know. Oh, you know, it may be because that case is in California. You know, California real funky acting about their trial coverage. Like they sitting on top of the world with the gold mine trials, and then you can't see none of the stuff. Okay, so here is the state's response. Like I said, it's 33 pages long. I will not drive y'all crazy with that, with me reading it, right? But the state's response to the defendant's motion for new trial and supplemental briefing. So this is Catherine Fernandez Rundell, state attorney with the 11th Judicial Circuit of Florida. Request this court to deny the defendant's motion for a new trial. Here are the facts that they allege. The defendant was charged by the information with one count of second degree redrum or on or about August the 2nd, 2022. An author hearing was conducted and the court found proof evident presumption great on or about September the 7th, 2023. A stand your ground hearing was also conducted on or about September 4th, 2025, and the defendant's motion was denied on or about September 8th, 2025. The trial began on October the 6th, 2025, and a guilty verdict was reached by the jury on October the 16th, 2025. During the trial, the court denied both the defendant's motion for a judgment of acquittal. Defense filed the motion for a new trial on October the 23rd, 2025. Okay, so the verdict came down on October the 16th. The defense filed for a new motion for a new trial on October the 23rd, 2025. And the state is responding back on December the 10th, 2025. So in the motion, the defense claims several pieces of evidence was received by the jury were uncontroverted. However, only the material relevant facts as the charges are not disputed. So it's only the material and relevant facts as to the charges are not in dispute. The facts are cited by the defense, however, are in dispute. Defense then files their supplemental brief at nearly 2 a.m. on November the 21st, 2025. They said, y'all filing this stuff at 2 in the morning. It's saying the court should deny this motion as the greater weight of the evidence supports the defendant's conviction. The court should deny this motion as no error occurred during the state's closing argument. Even if an error did occur, defense made no contemporaneous objection to preserve the issue. So they saying that they didn't object. Defense agreed to the procedure to cure any perceived error. Thus, they were not prejudiced. Furthermore, there was not a fundamental error as the court had broad discretion to allow this curative instruction. And I guess they gave a curative instruction. So they say, get that crap out of here. Get that crap out of here. No. So it's saying, number one, the state proved beyond a reasonable doubt that the defendant committed second-degree reading wrong. During the course of the trial, the state introduced numerous pieces of evidence, including the 911 audio in which the caller, who was later determined to be the defendant, denied knowing the victim. Like, I don't even know him. I forgot she did that. You're right, Tanya. That was just their side of the story, because I forgot that she called 911 and she was like, I don't know who did it. I don't even know this man. Like, she was already making up lies. And I guess if you really doing something, I don't know. They saying that they submitted photographs of the blood trail depicting the path of the victim as he fled from the defendant. The contents of the defendant's cell phone showing her call log, as well as missing videos from the incident that was discussed at length during the trial that occurred 5 days prior to the actual incident. Of course, the autopsy photos and crime scene investigation photos and the defendant's interview, the ring camera footage that they submitted, the state witnesses' testimony. We won't go through all the testimony. That's just in the trial, but like I said, there is this 33 pages long. Look at all this stuff. They probably went through everybody's thing. And remember, she took the stand. I'm trying to see. This is just different people testifying. Okay, so they saying defendant's son, PJ, a minor, testified as well. This witness was the only one who was present for all the events. However, this witness was tampered with by the other defense witnesses and admitted to such. Oh, gosh. Oh, wow. This witness was the only honest witness that testified on the defendant's behalf, but did not testify in her favor. He testified that his father, the victim, was a truck driver and lived in his truck. He did testify that when the victim was not working, though he lived at the residence, that at times would sleep on a couch. He recounted the events from the incident that occurred days prior. And these events of the night of the incident, but made several important admissions. First, he admitted that the reason he was called to testify was solely to get his mother, the defendant, out of jail. Whoa. Gosh, I don't even remember that part of the testimony. Do y'all remember that portion of the testimony? Secondly, he admitted that his grandmother, the defendant's mother, was actively tampering with him and altering his testimony. He testified that he lives with his grandmother and speaks to her about the case at least once a week. He testifies that he sometimes forgets about what happened, and despite his grandmother not being present for certain events, she tells him what happened. Gosh, the grandma like, look, I want my daughter out of jail. She got this baby. Wow. I didn't know the son had got up there on the stand and said this was this clear in regards to how he was being tampered with and things like that. Because remember, they had him on video and we couldn't see that. So they had him like on video camera because I don't think he came into the courtroom, if I'm not mistaken. The witness was the only credible witness called by the defendant. However, the only credible thing that he testified to was the tampering his grandmother was committing. Remember, this is the same mama that was sitting out there watching on court TV and somebody snitched on her. Wow. They saying the defendant's mother, Josephina, she testified as well, as was the case with all the defense witnesses. The witnesses were inconsistent, combative, and not at all credible. I do remember that. This witness testified that she had learned that the defendant had been injured, and these injuries were caused by the victim. She testified that as a result, she came to Florida and planned to remove both the defendant and the children from the home immediately. She testified her plan was to move the defendant and the children to Texas to reside with her. She also testified that when she first saw the defendant, she informed her that they were going to pack up everything up immediately and leave, despite testifying that she was in Florida to immediately remove the defendant from the home. This witness testified that she went and visited several family members. This witness testified that she observed several acts of violence that violence that night committed by the victim. Oh, that doggone red line. But never called 911. She testified that she never attempted to remove the children from the home, nor remove the defendant, despite the claim that she was only in Florida to remove the defendant and the children from this claimed dangerous situation, which is really, really, really true. I remember we were questioning that in the check, like, why would she say she coming down here to remove the children from this dangerous situation? See some things going on. Don't call 911 and don't remove the kids. Just so y'all know, they do have it noted. This is a footnote. It says, look, it should also be noted during the break, this witness, along with the defendant's mother, Josephina Perez, was questioned by the court regarding potential violations of the role of the sequestration. This witness was questioned if she was watching the trial on YouTube and denied watching the trial live or watching any media coverage of the trial. An assistant state attorney who was also questioned during the break and testified that he had seen the witness watching the live stream of the trial and described in detail how he knew she was watching it because he'd be watching it too. Despite the denial at the time, the witness has subsequently giving an interview in which she now admits that she was watching the trial as it unfolded. Oh, gosh. So she got there in the court. Remember, she was questioned, asking her if she was looking at the trial on break while they was out there. And remember, she got up on the stand and she was like, didn't nobody tell me that I couldn't look at stuff and all of this different things? I guess I'm surprised because when she went, remember, because she said this on the stand, right? But then out of all of this OnlyFans right here, she's saying, the state is saying, despite the denial at the time when she testified in front of the court saying that she was not watching it, after the guilty verdict, she went and did an interview and admitted this. I'm surprised that she even when, I guess you got to keep your lies straight, and she can't keep her lies straight, but she was supposed to own that and keep that, like no matter what that assistant state attorney saw, she was supposed to own it. She'd have went after the guilty verdict and decided she wanted to give an interview admitting up to it. So basically, she really did perjure herself, or I mean, really, she was supposed to take that. She wasn't ever supposed to speak on that again. So I am surprised. Like she was supposed to hold her. She was supposed to not say anything about that. So they get their own. They self-snitching is the best snitching, right? Because they snitch on themselves. Like she was supposed to hold that down because it was her word against his word. So the rest of this is just the defendant's testimony. This is their thing in regards to the closing arguments, how they felt about it. Like I said, the document is 33 pages. Y'all do not want to hear me. Y'all do not want to hear me talking for no 33 pages of stuff. I'm telling you, self-snitching. Woo. It says, in the present case, not only did the court have the discretion to allow for evidence to be reopened, but the parties also stipulated to the introduction of this additional photographs and stipulated to the defense being given additional time to present additional argument. Yeah, so it sounds like yeah. So I guess I'll keep an eye on it to see. I think it goes back in front of the judge. The motions, review of the motions is set for January 9th, 2026 at 9:00 a.m. Motion to vacate judgment and sentence filed 10/23/2025. That's when they filed it. And it looks like we set for court on January 9th, 2026. Okay. That's crazy. Okay, let me see. Let me get us set up. I know y'all ready to get in there rusty and get some testimony in. So I guess we'll find out on January 9th what the judge decides. Let me go ahead and get our link for our new room. And that gives us our update on this case. I do have, I'm still working on that one case that I was telling y'all about last night. Oh boy, we still doing the editing of it. because it has a lot of gore. I guess is the best way to say it. Like it has a lot of yeah, it got a lot of blood in it. Got a lot of blood in it, a lot of cussing in it, and it got a lot up in it. So the therapist you may know, and I know, and everybody know, is currently in the process of editing the video so we can present it. Because we definitely probably can't do it all on YouTube. That's all. We'll probably get in a whole bunch of trouble for it. So we're going to blur out as much as we can, but still keep the content so y'all can understand what was going on in the actual situation. So as soon as that's ready, I'll get that video and that update out to you. We do have some updates in regards to a new trial that we'll be starting on January 5th. I'm still working on a little stuff for that, packaging it together. The one good thing about this is that since we're in a rewatch trial, you don't have to have, it's pretty much there. So guys, if you will click on that link right there that I put in the chat, put your seatbelt on, it will teleport you over to our case that we're covering. It's going to be the Melody Ferris case. We'll go ahead and continue. We are on day 9. Yeah, day 9. Day 9. So we'll be on day 9 over there. I'll see you guys over there. I'll play our outro song and peace. Yeah, we on day 9 over there. Wow.
When Sweet Pea taps in, you know the courtroom lights go bright. Trials running long, but the family's here every night. Mars on patrol, shadows showing out. This little YouTube corner's what community's about. Therapist you know, steady holding down the floor. Behind the scenes magician, keeping peace like never before. A banner king, a rule keeper too. Every channel dreams of a mind like you. Jason walks in and the ladies lose control. Down to earth king with the warmest soul. Film freaks, kindness, man, it's always on display. Fair and sweet and cheering folks along the way. And Maria from SA keeps the laughter rolling free. Joking, shining, keeping spirits where they need to be. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This courtroom crew is everything we admire. Yeah, no matter what the case so far, we're forever taking to trial. Take it to trial. Pretty brown girl, she'll tell you what's true. Sharp as a gavel, funniest in the room. Dr. Rachel pops in while she's busy running lines. Speaks her mind every time, cuts through like a knife. And Fowler brings the energy, jokes flying fast. Helping Sweet Pea backstage, making every stream last. And Zach's chosen, causing chaos just for fun. The resident cheater, but we love him, everyone. Here comes Maddie, handsome, quick with the line. A comedy sniper with the perfect timing. And Lynn with the updates, always loyal, always tuned. If true crime news drops, he brings it to the room. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. We debate, we laugh, we lift each other higher. This coral crew is everything we admire. Yeah, no matter what the case so far, we're forever taking to trial. Take it to trial. Shamrock keeps us trending, replay queen. Holding down the algorithm like a machine. SD's razor sharp, loyal through and through. And yes, she adores chasing nothing new. Drunky the bear with the courtroom fog. In Brooklyn in the house, always bringing that spark. Lighting up the chat like a shout in the dark. Barker loves her grand, speaks truth when it's time. Micrograms with metaphors straight up sublime. Barbara biggest supporter, heart counting vast. Looking for missing kids, hope to truly last. Only fan from Singapore, flag name but sweet. Still shows up with love every time he takes a seat. And even the part-timers keep this place alive. Curvier, Irish Amy, Capri Law, Hellcat, our tribe. Hearts wide open, stories shared, holding space because we care. From every corner of the world we climb to spend these nights together, one trial at a time. We're a family in the chat, side by side through every trial. Sweet Pea leads the way with that fire and that smile. Mods and shatters, yeah, this love is something rare. A courtroom crew with hearts beyond compare. No matter what the case or file, we're forever taken to trial. Just sweet Pea in the mouth and the chat we adore. This isn't just a channel, it's a family. And we couldn't ask for more.